Good afternoon. Welcome to the Appellate Division. We have approximately 5 hours of argument time requested, so only ask that the time you need, not the time you wish. If we have more questions, we will keep asking them, and we are familiar with the briefs and the records in these cases. People versus Tarazona, appellant. That is submitted. Stanley versus City of New York, appellant. Respondent? 5, 2, and 4. New York Marine versus Millennia Insurance, appellant. Respondent? 5, 2, and 5. Zerger LLC versus Bucher Law, appellant. Respondent? 7, 1, and 7. Hartford Ferrer versus Hudson Excess, appellant.
5 and 2.
Respondent? 5, 2, and 5. Hussein versus City of New York, appellant.
7 3 R.
I'm sorry, what?
7 3.
Respondent? I'm sorry. 5, 1, and 5. People versus Jamily Williams, appellant.
8 and 2.
Respondent? 7, 1, and 5. CSI IT versus Dunie, appellant. Respondent? 6, 1, and 5. Rockmore Contracting versus City of New York, appellant.
8 and 2.
Respondent? 6, 1, and 5. Bansa, Ferrer versus SRIP. I know there's 3 parties here. Appellant, first appellant?
Opponent, 5 and 2.
Respondent, appellant, Your Honor, sorry about that, 6 and 3. Plaintiff respondent 6, please, Your Honor.
5, 2, 5, 2, and 6. Cereio versus Felder Billiards, appellant?
5 and 3.
Is there a respondent here? 5, 1, and 5. And Montgomery versus Manzueta is submitted, and Surveillance Tech versus New York City Police Department is submitted. Our first case is Stanley versus City of New York.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for appellants. Public health law, section 4201, allows individuals to use a proxy form to designate a person to control the disposition of the
Counsel,
remains.
let me ask you a question.
Yes,
The case law is pretty clear that you need to show both that you're next of kin and that you're someone entitled to possession of the remains. And those are the 2 issues in dispute. How has the plaintiff in this case not established those 2 elements? There's no real dispute that the plaintiff had the right to disposition through the signed document. So is your argument that a domestic partner is not a next of kin? Is that the primary argument?
is that issue is not before the court because it was
Well, why
explicitly
isn't it
disclaimed.
before the court? Because to see if there's a cause of action, you look whether the elements are satisfied, and I don't understand why the elements are not satisfied.
I guess the argument there, and we put this in our brief, is that, you know, there's no case law that says that a domestic partner qualifies as.
Are you,
Okay,
I just want to clarify that you're willing to state in open court today.
No,
that
no.
Your argument is that a domestic partner is not a next of kin, and that we should hold in a decision that a domestic partner is not a next of kin?
I'm saying that question is not in front of the court.
Well,
and is-
are you arguing that that's what we should hold?
No, I'm arguing you shouldn't reach it, and I'm arguing that
Shouldn't reach it?
the holding of the court below needs to be rectified because it's
Right, but if the
incorrect.
court got the law wrong, and the law is that you have to show those 2 elements, next of kin and right to remain to the body, and that's the law, and I don't think anyone really disputes that law, then why shouldn't we reach the issue of whether or not it's been satisfied and reach the issue of whether or not a domestic partner is a next of kin?
Well, again, because it hasn't been briefed, it hasn't been preserved, and you'd still have the case law, you'd still have a decision from below saying that a designation as someone who.
Right, but we're a correction court, so if the court erred in how it found the elements, what elements were required, why won't we correct that, enunciate what elements are required, and reach the issue of whether or not those elements are satisfied in this case?
Right, I don't think the question was that they had the elements wrong. It's that they said that the question of whether someone met the next of kin requirement could be satisfied by the designation of the person to,
Right, but if your argument is that you can't meet the next of kin by the designation because they're two separate elements, and let's say we agree with you, then what's the next step that we have to do as a court to resolve the issue?
well, I think that they would have to go back and see if they could independently.
Why can't we decide the issue of next
Well,
of kin? Why can't we
you
decide?
can, I'm saying for
Why
prudential.
can't we address the issue of whether a domestic partner is next of kin?
Well, you certainly can. I mean, I'm just saying as a prudential matter.
Why shouldn't we find that a domestic partner is next of kin?
Well, again, I don't know that we have a specific position on that, Your Honor. The only reason I could offer you as to why the court might want to have some caution on that, as we put in our brief, in that next of kin is a defined term under the Estates and Powers and Trust Law. It's the persons who are entitled to intestate distribution. And that particular statutory provision does not include domestic partners. There's a different provision of that law that deals with wrongful death, and I know there have been attempts to amend that statute recently to include domestic partners, and it actually passed, which indicated the legislature felt they had to specifically add domestic partners into that statute in order for them to be entitled to bring a wrongful death action.
Your suggestion that we remand this would mean that plaintiffs' rights, the length of time for which during which plaintiffs' rights were not recognized would be extended and ignored by this city. Given that the case law says that that one of the elements is whether the interference caused the plaintiff mental anguish, which is generally presumed, it seems to me that it would be a very peculiar result for us to make this process take yet longer when I don't see any basis in law or policy for your position that a domestic partnership does not create a next of kin relationship. It seems to me that the whole purpose of that law was to recognize a category of people who, as next of kin, who had not previously had a means to do so. So it seems to me you're asking us to take the law in a backwards direction. Explain to me why you're not doing that.
Of course, Your Honor. I guess two things to that. The first is that we're here only on a grant of partial summary judgment on liability. So the question of damages would still be litigated either way. We still go back for that regardless.
But you agree with me that that is whether or not the interference caused the plaintiff mental anguish, which as a matter of law is presumed, right?
It's an element, and that element is not at issue on this appeal, but they still have to prove the extent of
Do you
the
agree
damage.
with me that's an element?
Yes, I do, Your Honor.
Thank you.
Thank
And
you. We have time for rebuttal.
Good afternoon, and may it please the court. Remy Green for respondent. I'd like to start by framing this with the fact that we are talking about a common law tort. So we are not bound by statutory text. We're bound by the court's interpretive power and its ability, as Chief Justice Kern was suggesting, to craft remedies that move with the times.
Are there any cases which address under the common law whether a domestic partner is next of kin?
Yeah,
Or would
yes.
this be a case of first impression?
Yes, Your Honor. We even cited it in our brief, although my friend on the other side seems to pretend it didn't exist. That's Graham by a New York County judge from 2025. But so yes, the answer is yes. I think the other thing I do want to focus on, though, is that the city's argument is that to get any, that if somebody tries to exercise their rights under Section 4201, that person necessarily is abandoning any remedy. As the city says in their brief, 4201 does not correspond to to the estates law. And so if they're right that you look to the estates law for next of kin and 4201 for right to possession, what the legislature did after September 11th was break the right of sepulcher such that you could not get it if you designated somebody. And in fact, the default rule for many people, because those lists do not correspond, is that there is no person with the right of sepulcher. I think that the elements of the common law tort here are really not aimed at kind of a traditional six-factor test, but really at figuring out who is the right person to bring this action.
But isn't there a large body of case law that holds that both of those elements are required, right to possession of the body and right to be next of kin, and that those can be different people? You can have the right to possession of body but not be next of kin. You can be next of kin, not have right to possession of the body.
So I'm less than sure that that's true. At least prior to 4201, those elements almost always, if not always, and I'm not aware of a single case saying that they didn't travel together. That is, next of kin would always be the person with the right to possess the body because that right comes with being next of kin.
Right, but you can give statutorily give someone right to possession of the body without necessarily giving them a right to bring a cause of action on your behalf. It might just be some reason that you want someone to be able to control the funeral, but that doesn't necessarily mean they're next of kin or have that type of relationship to you. So since it's filling out a form, there could be many reasons. You could have your lawyer have the right to, so how can you not, I mean, I don't know if it matters if you win on having both those elements either way, but how can you not require both of them?
Right, so 2 points. The first, as Your Honor just pointed out, that doesn't necessarily matter in this particular case because she's next of kin anyway because she's the domestic partner. Again, Graham says that, and I think that that's common sense. But the second is we are dealing with a common law tort here where the court is at kind of the peak of its interpretive powers, and it does have the ability to craft it to account for the background law and look at that. So the city's position, again, up until 2003, I think it was, when this law was passed, when 4201 was passed, next of kin and right to possession always went together. And the problem is if you separate them, you will actually end up making it so that for any particular decedent, there's no one to vindicate the right to sepulcher because those people could be different, right? The first person wouldn't be able to bring it because they didn't have element one, and the second.
What's wrong with that?
What?
What's wrong with that? What's wrong with separating it? I mean,
because then no one has the right. You could have a violation of somebody's undisputed right to sepulcher, or that right of the decedent is violated without anybody able to vindicate it. That's not. I mean, typically that's not how we do common law.
thank you.
Just wanted to briefly note, Your Honor, that the sort of problem with that analysis is that the right to sepulcher doesn't belong to the decedent. I keep talking about
So
how
if you could speak up a little.
the right to sepulcher doesn't belong to the decedent. They keep sort of framing their argument in the sense that like somebody has to vindicate the decedent's right. It belongs to the surviving next of kin.
Right, the pain is the survivor by not having the right to
And
possession of the
right,
remains.
and as Your Honor noticed, you could have had this separation before that Your Honor was talking about because you could have designated in a will somebody who was not a kin relationship to handle the disposition of your remains. And there's no indication that the legislature in enacting 4201, meant to change the scope, the elements of a sepulcher cause of action.
Thank you.
Thanks.
New York Marine versus Millennia Assurance. Go ahead.
May it please the court, I'm Marshall Dworkin from Saul Ewing, counsel for appellant plaintiff, New York Marine and General Insurance Company. I may refer at times to our client as New York Magic. We ask the court to reverse the lower court's denial of New York Magic's motion for preliminary
Let me
injunction.
ask you to actually focus first on, I know the court below held there was no irreparable injury, but but I'm going to ask you to focus first on the likelihood of success and the merits. How have you concretely showed in your submissions the likelihood of success? And that there
Yes.
is actually an under-collateralization and what that amount is?
Well, we show that through the Crow affidavit or affirmation, where he attaches documents, but he also affirms that the collateral required in the trust was at the time approximately $9 million, and it was underfunded by approximately $5 million. And that's both his testimony and the documents, which come both a collateral review statement, which is the quarterly report that they provide Millennia Assurance, the respondent, and also a screenshot that shows the Comerica, the
I will
trust.
say that because you're not presenting these documents to people in the insurance industry, that there was not a lot of explanation provided as to how to walk through these documents and walk through the figures.
I understand that. Going to the actual reinsurance agreement, there's no requirement that we have a big explanation. You know, to invoke their requirement to collateralize the trust, it just requires a demand.
Okay, there's no, even if that's true, to show a likelihood of success on the merits, you do have to show that there's been an under-collateralization, because if that hasn't occurred, then there's no reason to replenish the trust account. So that has to be part of what you need to establish in this case.
Sure, and I believe that we did. And frankly, the court below didn't even get...
Is it because they said you're seeking some certain monetary relief and therefore no basis for an injunction? Is that where they were coming from?
Sorry, I'm not... You're talking about the lower court or respondents?
The lower court.
The lower court. But the lower court didn't address it at all. They didn't address really the main thrust of our argument. You know, if you look at the decision by the trial court, it is based really on two things: his 50 years of experience in the insurance and reinsurance industry, which we respect, Justice Ostrager. He's very knowledgeable, but that's not a basis for making a decision. And two, the size of our client, that they have a large surplus. You know, he really
The
doesn't...
whole idea of a captive insurance company is that it's not your surplus you should be looking to, it's the captive insurer who you're supposed to be looking to.
Correct,
So,
correct.
with all respect, that wasn't really the thing that needs to be focused on. Let me ask you something. I know the basis for denying it below was the irreparable harm. Do you think that Atlantic Specialty versus Landmark controls that issue in terms of whether or not you've shown irreparable harm in this case?
Irreparable harm? I believe we do. I mean, there are nuances between a surety and a captive reinsurance. You know, surety, it's like 2 or 3 claims. They're speculative somewhat. You know, it could be a class action where you're not, you know, it's not clear whether, you know, what the scope and whether they've collateralized correctly. Here, it's much more straightforward because it's an insurance company that's highly regulated, and Regulation 114 trusts are highly regulated, and they provide financial statements certified to the Department of Financial Services. So it's the speculation and whether they've, you know, likelihood of success is, I think, a little bit more easier to satisfy here than Atlantic Specialty.
Let me ask something. What's the significance of the Schedule F penalties? Like, what process is involved? What determination has to be made by the regulator in order for the regulator to impose a Schedule F penalty, which I know has already been imposed against your client?
Well, it's somewhat, my understanding of it is somewhat self-reporting, is that they have to report in their financial statements whether they have all the collateral required for each of these reinsurance arrangements. So we submit in our financial statements yearly that shows the underfunded, and we report the Schedule F penalty. And so it lowers our policy surplus and the ramifications in our brief that kind of come from that.
And is that part of what your irreparable injury is, the Schedule F
that is-
penalty and the ramifications that flow from that?
That is part of it, but the main thrust is that as a matter of law, because this is an indemnification agreement, the failure to collateralize is in and of itself irreparable harm. It cannot be solved through monetary damages.
Or that there are no defenses that they could possibly raise for this, for failing to put in the money.
Well, I think under the law, the only really defenses they could have is if they allege fraud or they allege...
They did not challenge Mr. Crow's affidavit made based on personal knowledge, correct?
I think they mentioned personal knowledge, but we disagree
well-
with what their argument was.
They claimed it was an admissible paper for purposes of supporting
Correct.
your
Correct.
motion.
Correct.
But in reality, he was an officer of Marine with personal knowledge, correct?
100%. That's a great point.
Thank you.
May it please the court, Alexander Sperber of Lipsius Benheim, on behalf of Respondent Millennia Assurance, Inc. This appeal arises from a
Let
pre-answer.
me ask you, why doesn't the decision in Atlantic Specialty versus Landmark from our court, which I know is a surety case, but why isn't that controlling in terms of the concept of constituting irreparable harm in this case? That the mere fact of not having enough security to cover it creates a flow of damages that are unascertainable.
I would say two things in response to that, Your Honor. First of all, before the court can even get to that question, there has to be a showing that there is a lack of collateral. And
Well, I was trying to do it in the order of the decision below, so why don't you quickly answer that, and then I will ask you about the lack. One of us will ask you about the lack of collateral.
sure, and so number two would be the line of surety cases deal with instances where there's a fixed amount of money that's owed. There's an agreement that says so-and-so will provide, I don't know, $5 million in collateral. So you know how much money has to be provided. In this case, under the reinsurance agreement here, the amount of money that's owed is subject to a very complicated formula with a number of inputs. And so it's not so simple to say this is the amount that's actually owed. You have to look at a whole list of different.
Let me ask something, because this goes to the likelihood of success on the merits too. Putting aside the fact that they filled out, made a form and showed the amount of lack of collateral, there's Schedule F penalties. No company is voluntarily going to provide information and let themselves be penalized by an insurance regulator unless there really is an insufficient collateralization issue. So why isn't, first of all, the form attached to the affidavit and the fact that there are Schedule F penalties enough conclusively to establish a likelihood of success on the merits?
So the entire affidavit, first of all, it's not based upon personal knowledge.
Well, he's a servicer, so he has knowledge as to these things because he services it.
It's not clear that he is a servicer.
Well, did you put in any affidavit to contest the allegations made by Mr. Crow?
No, Your Honor.
And what about the amounts? I mean, you didn't really
was a-
contest that, so.
This was a pre-answer order to show cause. We hadn't yet had the opportunity to do any discovery.
No, I understand, but you could put in an affidavit as to how you disagree with what they say. I mean, that would be in your knowledge. But, I mean, he put in an affidavit. He was the servicer. He explained where he got his knowledge, and he attached that form as part of, as an addendum to his affidavit. So if you don't really contest it, it's tough to.
We did contest it, Your Honor, and to be clear,
How did you contest it? You're contesting it with saying that he didn't have personal knowledge. There really wasn't much else that you put forth in your brief as to why it was actually incorrect in any way, or for a counterversion of how there was sufficient collateral.
as the movements, they bear the burden of showing the elements of the.
Right, but they put forth evidence. They put forth. But what did you put forth in response to show that that was incorrect and that there was sufficient collateral in the trust account?
Their evidence is solely an affidavit not made upon personal knowledge from someone who does not even work for New York Marine, who doesn't explain where he gets this information from, who told
So
it
you're
to him.
you're pointing to holes in their proof to try to show that they haven't proved it. You're not pointing to any contrary evidence that these numbers are incorrect somehow, or the calculations are incorrect somehow, or giving any explanation to how there was Schedule F penalties, other than that there wasn't sufficient collateral.
I could address each of those, but on the Schedule F penalties, a Schedule F penalty is effectively a decrease in New York Marine's ability to write insurance. There's no evidence before the court at all that they've utilized the full amount of their surplus to write
Right,
insurance.
but they don't have to use, that's the whole idea of a captive insurance company, that you shouldn't have to go to your own surplus to pay those things. That's the sole purpose of having a captive. So the captive will be available to pay the claim. So I don't understand how it's relevant what their surplus is or is not, because they're not supposed to go to their surplus.
Again, there's no evidence that there is a penalty at all. The
Yeah,
entire
but,
affidavit-
sir, did you deny the shortfall? In other words, they came up with $5 million shortfall. and you recognize that the 114 trust is a guarantee of payment. It's a clean and unconditional money, no strings attached. You had to do it under the agreement. Did you deny it? You deny that there's a shortfall regardless of whether there's $1 billion surplus here?
We do dispute the amounts that are
How
owed.
did you do that?
We didn't submit an affidavit in response, but that's the nature of our defense, at least in part, is that there's a dispute over the amounts of money that are actually owed to New York Marine. This is not before the court, but there's a dispute over access to documents underlying the amounts that they're claiming are owed in this case.
You didn't put in an alternate calculation.
We did not, Your Honor. We were relying upon the lack of evidence to support their motion as
Thank
was
you.
submitted.
Thank you very much.
Thank you.
Counsel, if I may, I want to go back to Mr. Crow's affidavit because it seems to me that it was very detailed with respect to the source of his personal knowledge as well as his investigation and the fact that the Schedule F penalties were difficult to quantify, around 600,000, and it would be even more around 2023.
Yeah, it was at the time was 600,000.
Right. And so counsel here just said, that's not sufficient, but they didn't do anything to challenge that.
Correct. The only thing I'd really like to add, I guess, on rebuttal, is one point is made is that they're disputing the amounts owed or the amounts in this collateral, like through the course of this litigation, for the purpose of preliminary injunction. And multiple of these, cases that we rely on say, this isn't the time to resolve disputes of facts, disputes of numbers. That is for the trial ultimately. If this is a reasonable amount requested and they're certainly required to collateralize the trust, then it should be ruled upon on a preliminary injunction. Frankly, as a matter of law. So the dispute over numbers, I don't think is sufficient to deny a preliminary injunction.
And one of the numbers that you concede, that you claim is irrelevant, is their argument that because of the massive amount of assets of your client, that's totally irrelevant given them as a matter of law.
Correct. That's completely irrelevant.
Thank you.
Thank you.
Zerger LLC versus Bucher Law.
Good afternoon. May it please the court. Seth Kugler on behalf of defendant appellant Bucher Law PLLC. Let me introduce David H. Shaw, my co-counsel, who is arguing by permission of the court.
Thank you for the opportunity to appear today. The deciding factor in this appeal is whether William Bucher had a primary or substantial role in representing the STEAM mass arbitration clients within the meaning of Rule of Professional Conduct 1.4. The answer is yes. Zerger LLC's complaint admits that he did. If you look at paragraph 65 of both the original and amended complaint, alleges that on March 24th and 25th of 2023, Zerger LLC sent an email to the STEAM mass arbitration clients announcing Bucher's departure, quote, consistent with its obligations under Rule 1.4 of the New York and Connecticut Rules of Professional Conduct. Zerger LLC would only have had an obligation, to use its words, to make a disclosure under Rule 1.4 if Bucher had a role that triggered that obligation.
Isn't it quite possible that they were just being very cautious but didn't actually think he had a role?
I can't get into their heads, but I think that the evidence that we have supported is consistent with this pleading that this was their obligation.
I think if that's all you had, that would be a problem.
It would be an admission in our mind, Your Honor, but we have more than that. The pleading does not say, as a precaution, we did this. It says consistent with our obligations. We've offered a record that has many other items of evidence, including the offer letter, which says that Mr. Bucher was leading that practice. There is the implicit admission that they agreed to a joint statement for the 14,000 remaining STEAM clients. Just one.
I'm a little confused. You basically moved pursuant to 3211 to dismiss Zerger's claims against them, a variety of claims. tortious interference with contract, violation of the competition clauses, et cetera, et cetera, et cetera. And the court's failure to consider what you've done of public interest in terms of the anti-SLIPE statute. You seem to be zeroing in on conduct which actually keeps you in New York when you don't want to be in New York, right? You want to be in Connecticut.
Fair enough, Your Honor, but
So you're sort of like, you're missing the whole point here.
but we would agree that the rules of professional conduct here are relevant both to the
I'm
anti.
mystified though too, like how this plugs into your arguments about the anti-SLAPP statute, your arguments about, you know, the specific causes of action. How does this argument fit into, is it fit into your argument about whether or not it's a purely private matter versus, I mean, how does it fit into the argument?
So on the motion to dismiss for failure to state a claim, if Rule 1.4 applies, if Bucher's disclosures to these clients were ethically mandated, none of those claims state a cause of action. Likewise, with anti-SLAPP, the elements of anti-SLAPP are, is it lawful conduct and is it in the public interest?
How can a private agreement such as this between the law firm and its clients be of public interest to trigger that statute?
Well, the best evidence of that, Your Honor, is 1.4. The courts, in promulgating that, the New York State Bar Association, have spoken and seen the public interest in clients making informed client choice. There's the contents of the communications themselves, but context also matters. The fact that Bucher was making a mandated disclosure that these bodies found to be in the public interest makes it in the public interest. That imbues it with a public interest character.
Counsel, I'm actually looking at pages 406 through 407 of the record, the survey letter to the client. And my question is, was that issue raised in the letter? Because what I have here is really a solicitation to have clients move away from Zerger to the other firm. I don't see anything about any ethical concerns here.
The
The survey client letter to clients.
Sure.
Pages 406 to 407. And it really is a solicitation. So I don't see anything in here about what you raise.
First of all, it's not a solicitation. It does not solicit them to go from Zerger to Bucher.
Okay, well, that's my, interpretation of it.
It informs them of their right to client choice. And if you look
Right,
at
but
the
it's
survey,
Counsel, all it's saying is you can pick our firm or you can pick the other firm. How does that, and it's to a limited group of specific clients, how does that raise an issue of broad public interest as opposed to what's going to happen, which lawyers will this particular group of clients choose going forward?
the survey also says, I don't want either firm to represent me. That is
Right, but
consistent.
that's it's still going to a select group of people
Right.
about representation in a particular litigation. That sounds inherently private as opposed to a public matter.
Courts have found very limited circulations to still fall within the anti-SLAPP statute.
Right, but it's not the limited number that I'm referring to, it's the topic. The topic is about which firm do you want to stay with in this case. So it's not about a topic of public interest, it's a very specific topic. You're supposedly coming into this litigation because you believe you will have some pecuniary gain from participating in it. How does that implicate a greater interest?
It does, because one, he's saying you have a right to choose, and if you look at the content in isolation, I see your point, but you also have to look at context. He sent this message because he had to. Under comment 7B of 1.4,
Whether he had to or not, and we don't really have to decide that issue, I don't know how that changes anything, because and it's very broad, but it has to be something involving the public interest. The fact that he might have personally felt an ethical obligation to send this letter to these people, which we can debate, how does that bring it into the public interest?
because the rule decided it was in the public interest to require him to send it. He was proceeding in compliance with a rule where other bodies had determined the public interest in clients getting these disclosures.
Thank you.
Good afternoon. May it please the court. Greg Tuttle from Tuttle Yick on behalf of the plaintiff respondent, Zerger LLC. I'll jump right to Your Honor's questions about anti-SLAPP. The first threshold question is whether this falls under the anti-SLAPP statute, whether it was an exercise of free speech about a matter of public interest, or was constitutional petitioning activity, this solicitation. The trial court correctly held that it was neither. To implicate the anti-SLAPP law on the public interest grounds, the communication must have some relevance to the public at large. As this court confirmed a few weeks ago in the
What about the argument he's making, which is that because it was an ethical obligation to follow up with these clients, that somehow brought it into the public interest?
I don't think that makes any sense, Your Honor, because the content, what this court said in the Miller case is that it's the focus of the communication that the court needs to look at. The focus of the communication wasn't about attorney ethics. This wasn't a missive about the right to choose counsel or Rule 1.4. The focus, as the trial court held, was a pure solicitation.
Yeah, it was about how many arbitrations he successfully won or settled, his role in the American Bar Association, right?
Exactly, Your Honor. And put simply, the broader public or broader community just does not care which private law firm any particular individual engages to pursue a private arbitration. Solicitation included no broader policy discussion. It was just simply hire me and fire Zerger. That was the whole point of that case. And I would also direct this court to I'll probably butcher the pronunciation, but the Rakosevich case in the Southern District a few months ago, cited in our brief. That was a similar fact pattern. It was a law firm bad-mouthing a departing attorney to his client, saying that he was involved in unethical conduct and encouraging them not to take their business with him. I think that was a closer case because at least it talked about the unethical conduct of this attorney. It had some substance in these communications. The court still denied anti-SLAPP protection, relying on this court's decision in the Miller case because the focus was clear. It was just to, and I'll quote its words, dissuade their clients from continuing their business with the attorney. It's exactly what happened here. This is of no interest whatsoever to this gentleman.
Sir, cutting to the chase, the court, the motion court was basically analyzing each of the pleadings here, correct?
Correct.
Did an analysis to determine whether you sufficiently alleged allegations, and she construed it in the light most favorable.
Correct, Your Honor.
And did that analysis. Pretty straightforward.
Correct. Correct. The court first said that the anti-SLAPP law didn't apply, so it would apply the 3211A7 standard, and said that Zerger stated a claim. That's exactly what it did.
Parenthetically, my understanding is that they also sought to dismiss, or at least to stay the New York action based on a pending action in Connecticut in federal court, but that's been dismissed, correct?
The Connecticut action has been dismissed, and that stay was not pursued on appeal. Going to the right to petition, the communication certainly doesn't further anyone's constitutional right to petition. That's for two reasons. The communications are trying to encourage are trying to encourage clients to hire Bucher to pursue private arbitrations, not private contractual arbitrations, not litigation. It's pretty clear what the constitutional right to petition means. It's right there in the First Amendment in the New York and the US Constitutions. It means petitioning the government, that is the courts, the legislature, administrative agencies. And even if somehow communications in furtherance of private arbitrations could be called petitioning activity, this communication wasn't anything like the kind of petitioning activity in any recognized sense in any anti-SLAPP case anywhere in the country. These were not pre-litigation communications discussed in any that were discussed in Bucher's authorities, not demand letters, communications to an adversary. This was pure marketing, pure solicitations. And Bucher cites no case anywhere that extends anti-SLAPP protection to this kind of private solicitation that contains no legal advice whatsoever. In contrast, the WHGC case, which is in page 22 of our brief, involves facts very similar to us in pending litigations in which a departed attorney solicited firm clients. The court said those solicitations did not warrant anti-SLAPP because they weren't about anything in the judicial proceeding. Again, these communications did not involve anything in the legal proceeding. Moving on to the substantive challenges to the amended complaint here. The attack that the defendant has taken on each of the causes of action is about whether the complaint has sufficiently alleged wrongful conduct, some independent tort, wrong, or improper means sufficient to support its claims. We submit this immediately raises disputed fact issues and even expert disagreement that would easily defeat a summary judgment motion, let alone a pre-answer motion to dismiss here. The complaint details the wrongful conduct here, and the opposition to the motion, bolstered by contemporaneous evidence from clients who felt that they were misled by the solicitation, sworn testimony from clients, and even expert opinion here. The wrongful conduct is manifest. Here, it's that Bucher took Zerger's client list, and then after being fired for cause for changing the permissions on the firm database without authorization, swore that he hadn't, then he used that list for this improper solicitation. Theft, perjury, using the fruits of those are absolutely the kind of wrongful conduct that can support a tortious interference claim here. And second, putting aside of how the client list was obtained, the solicitation itself was wrongful, and we point out why it's materially misleading in detail, and our expert also opines on that issue. It was crafted to trick clients into thinking that they had to act now to protect their rights. It said that action was required when it wasn't. If they did nothing, obviously Zerger would continue to represent them.
Any problem with the court's decision? I mean, it was raised by in your briefs as to applying the motion to the amended complaint, which came out after the motion was made.
I don't think so, Your Honor, because that was the only operative complaint under this court's decision in Rome and CPLR 3025A. The amended complaint, a plaintiff can file an amended complaint in opposition to a motion to dismiss as of right. It was the only operative complaint the court could apply it to. Nothing in 3211G changes that. No other provision in the CPLR changes that. All it does is stay discovery and motions, but not new pleadings. It was the only complaint it could apply motion to. Thank you, Your Honors.
I believe counsel said there was no interest in what lawyers represent the steam mass arbitration clients. The record at 112 to 129 includes a number of articles, not about this dispute, but articles regarding the integrity of the lawyers representing these steam mass arbitration clients. There is indicia of public interest on this issue. I would just like to wrap up and say we've, I think, established under 1.4 that there were ethical mandates that required Mr. Bucher to act as he did. He's been sued for it. In terms of client choice, clients have chosen. About a third have gone to Mr. Bucher. The rest have stayed with Mr. Zerger. What's left is this zombie litigation where they've attempted to weaponize these claims against someone that, a lawyer that was doing what these guidelines and ethical requirements required him to do in reaching out to these clients.
Thank you. Hartford Fire versus Hudson Excess.
Good afternoon. May it please the court, Stephen Lubell on behalf of the appellant, Hudson Excess Insurance Company. In this particular case, it's conceded that Hartford did provide late notice. Hartford then had the burden in this case to show, and it's a well-settled burden since the late notice law changed, that there was no material prejudice and there was no undue impairment or inability to Hudson to undertake its investigation. A recent decision out of this court in December of 2024 articulated in fairly good detail as to what that particular standard is to show material prejudice in a case of this nature where there's a passage of time. And that's undisputed here because the accident occurred in 2017.
We've had a lot of activity recently on these issues in this court. I'm not sure which, are you referring to Madison?
240, yes, I'm referring to
Madison
244
Realty?
Madison versus Utica first, that's correct.
And why is this case like Madison and not like Salvo?
Sure. Well, yes, this case is like 244 Madison because in this particular circumstance, there were three three acts at least of prejudice that occurred to Hudson in this particular circumstance. One, they could not conduct a contemporaneous investigation. The accident happened.
That was also true in Salvo.
Yes,
So you have to show why this case is like Madison and not like Salvo.
well, I was going to say, in this case, there was a transient job site as well. Now, in Salvo, the issue in Salvo was there was a defamation claim in Salvo. That claim, no matter what, the passage of time did not affect that defamation. In other words, that defamation took place, and for all time, whether that was proved or not, it was etched in stone. Here, in other words, the passage of time in Salvo did not affect the ability of that case to be defended. In this particular case, the passage of time prejudiced Hudson because, number one, they could not conduct a contemporaneous investigation. They could not take statements.
They couldn't go to the site.
They couldn't go to the site.
They couldn't find the ladder.
They couldn't secure the ladder. Exactly.
And there were several witnesses that you claimed that you would have interviewed that the Hartford chose not to interview during their investigation.
Yes, Justice Capnick, that's right. The foreman, Quintana, Danu, Quintana, the Fadumani's, their foreman, Mr. Danu, the foreman for 177.
And discovery was closed, so you couldn't do any of this discovery.
We couldn't, well, we didn't have the opportunity.
Was the note of issue was filed by the time
note of issue was
this all
filed.
happened?
Not
Is
only,
that true in Salvo, do you know?
I'm sorry, Judge?
Is that true in Salvo?
I don't know off the top of my head in Salvo, but I will say that not only was the note of issue filed in this case, summary judgment motion was in full swing. Or plaintiff had already filed their initial briefs for summary judgment in this case. So
Did you articulate any defense you would have developed if you had been given the opportunity that you lost the opportunity?
yes, Justice Kern, the recalcitrant, most prominent, the recalcitrant worker defense was not fully explored. Number two, and
And that you could have explored it more if you had been brought in earlier, gotten notice earlier.
yes, because there could have been a deposition of Danu, the foreman for 177, the immediate superior for Mr. Lee, which the case law states that if the immediate superior had given orders and it was not followed, that enhances the recalcitrant worker defense. Danu was never deposed in this case. There's also issues with regard to developing a self-certifying medical record. There were statements in the medical record that the underlying plaintiff said he had lost his balance. That was never developed. There was no certified medical record that was submitted below, and the court never even addressed that issue, but there would have at least been a competing statement of fact. Case law says that if there's a competing statement as to how the accident occurred, there could have been a question of fact and defeated 240, a label or section 240 claim of the plaintiff. So there were numerous issues that had Hudson at least had the opportunity, and especially in this case, because there's one feature here that many times is not seen in a personal injury case. Mr. Chen brought his case 26 days after the accident, meaning that we're not talking about 2 or 3 years later, we're talking about 26 days. If Hartford had
It would have been a lot of time to do discovery if you had gotten the notice.
Yes, Judge,
Okay,
there would have
thank
been a
you.
lot of time. Thank you.
May it please the court, Yale Glazer, Lazari, Potter, Jacobus, and Moyle for plaintiff's respondents.
Counsel, there's no dispute about that it's more than a 2-year delay.
We're not
So
disputing
The
that.
burden is on your client to show the lack of prejudice.
That's correct, but can I do?
How are you doing that?
Well, Your Honor, if I can just direct Your Honor to the peerless argument first, because I think that's dispositive without even getting.
Except we never apply peerless. When do we ever, what cases do we apply peerless in?
Well, it's the Second Circuit's done it, the Southern District's done it. I think you're.
But where do we apply peerless? Where are the
I do
cases
not-
where this court is applying peerless?
I do not yet have a case where this court has applied peerless, but it makes sense.
If we were going to apply it, wouldn't it have to be applied in a case where there's no question that they had all the knowledge at that point when they initially denied coverage, they knew all the circumstances, and still asserted that defense, which is clearly not the circumstances in this case. It was so early on
Your Honor,
when
though-
they first had to make that denial of coverage.
If you look to their coverage letter on page 363 of the record, they came out and said, let's assume that we have all the contract information we need in this case. It still doesn't matter because they have not established that it arose out of the acts or omissions. It was caused in whole and part by the acts or omissions. So what they're saying is, we're going to assume we've got all the contract documents we need that establish that the additional insured is.
Counsel, if we applied that case, and I think there's reasons we don't apply it, wouldn't that put an impossible burden on insurance companies in terms of having to make an early determination about how to disclaim coverage? Is it the normal rule, you put everything in and then you develop it to find out what really is true, or else you'll lose that right to assert it?
Well, no, you can't lose the right. If they don't qualify as additional insured, that can't be waived. It's not like a limitation or exclusion, right? They either are an additional insured or they're not, and you don't even have to disclaim coverage.
Right, but why should there be such draconian consequences based on that early statement, which is what Peerless would seem to do?
Well, because it's not an early statement. It's the insurance company's position in this matter. They're saying there is no coverage because there's no proof that it arose out of, that it was caused in whole or in part. So what that means is, even if we have the document saying it, we're still taking the incorrect position. And
So
by
this is a unique case where we're finally going to apply Peerless under these facts? Is that?
I don't see why not, Judge.
Okay, assuming for purposes of the remainder of the argument, we're not going to apply Peerless, why don't we address the significant prejudice?
So there is no, for all points, there was full defense by mayor, by council appointed by Hartford.
Why isn't this case like Madison Realty, where the court said discovery is closed, they had no further
discovery wasn't
opportunity, the
really-
note of issue was filed, just like our case? Why isn't Madison dispositive in our case?
Discovery wasn't really closed here, Judge. They filed the
Wasn't
note of issue. The
filed?
note of issue specifically said deposition still pending, IME still pending. You know how the courts say you have to file your note of issue by a date certain, but discovery still goes on. The note of issue was filed on February 25th, 2020.
What about the fact that counsel said that there were pending summary judgment motions?
Summary
and-
judgment was not filed until May 28th, 2020. They were provided notice in March to their broker, March of 2020, and then March 18th directly to them.
It's not a lot of time.
Not a lot of time, but opposition to the summary judgment motion wasn't filed until December. This case was not moving along quickly. So
But speaking of notice, you had notice years before that
We didn't-
Hudson,
the
excuse
problem-
me, that Hudson was the insurer, right?
problem is, there was a mistake. There was a mistake. And so we have already said,
So we should protect you because you made a mistake? I
well,
don't
no,
understand.
because the standard says there has to be material prejudice to them, right?
Right, and why haven't they shown material prejudice? I thought counsel outlined in some detail all the discovery they would have done if they had been brought in earlier.
But they still
And then
could have
also,
done-
let's add the fact that the TS group dissolved, they were never deposed. Let's add that too, to the mix.
Hartford never got the full contract until 2021. Hartford can't produce something it doesn't have, but notably,
I'm not sure about that. October 23rd, 2017, there's an email from Hartford, contacted Gordon, sent the insurance certificate.
certificate of insurance, Judge.
But I'm still speaking. From Damani and TS Group, and also requested a copy of the contract. And at that point, it said, yes, we believe that the employer was TS Group.
there was no dispute about who the employer was, Judge. The dispute was who was TS Group's carrier.
Well,
And in this
then you
situation,
can
so
find that out when you know then.
And you knew it was Hudson.
we should have known it was Hudson. It was an
The
administrative
information
upload.
was supplied to you that allowed you to, that would, if you had noticed it, would have made you realize the insurer was Hudson.
Correct. We would have, but that doesn't change the fact that there has to be material prejudice. They were defended the entire way, and all the arguments they're making, the change.
Well, I thought he explained, he certainly made allegations that there were several people who had knowledge of the transitory incident, the accident that occurred to the underlying plaintiff, that were not ever deposed, that they would have looked for to depose or speak to or investigate had they known about it 3 years earlier. And they have made, and those people were, they were their supervisor. There were people certainly involved in the situation. They had the right to depose those people. I thought they made a good point.
I just want to go back, because I thought there was something in the record that there was an admission that plaintiffs had received TS Group's certificate of insurance from Gordon on October 24th, 2017.
The certificate of insurance, correct, Your Honor. What we did not have until 2021 was a copy of the full, complete copy of the contract. What they're saying what they didn't say in their letter, but what they said in their motion below is, we didn't have the full contract, so we couldn't make a decision. What they never discussed in any of their papers, below or here, is the cause-by argument. They completely ignored that argument, because that's dispositive.
Once you had the certificate of insurance, you had enough information to get everything you needed, right?
That would have given us information as to the name of 177's carrier. It doesn't give us the contract.
But it would have given you the information on how to do that and who to contact, right?
It would have given us the name of the carrier, Judge.
Thank you.
Thank you, Your Honor.
Let's,
Just very quickly, one of your positions in opposition is that Hartford's attorney zealously defended, correct?
Correct.
Did you point to anything in the record that countered all the points that your friend raised? For example, did you check the ladder? Did you have information on the ladder? Did you manage to depose principals of TS Group?
So as to the...
I mean, just by illustration.
Sure. As to the counsel below did address in its papers the sole proximate cause and recalcitrant worker in its papers. It did address the medical record issue. It did, what was your other question?
The ladder.
The ladder. The ladder doesn't matter. And this is why the ladder doesn't matter. We're the owner. The owner testified, I've got no ladders. You got to keep it in separate, that their obligation to the employer, who's their insured, and to the owner, who's the additional insured. It clearly wasn't our ladder.
thank you. Thank you very much.
Thank you, Your Honor.
Thank you.
Just very briefly, I think the court hit the nail on the head. Hudson should not be charged with it being detrimental because there were errors made by Hartford in this case, and clearly the errors have not been explained, and all of this factored into the material prejudice that Hudson suffered. If the court has any questions, I'll answer. Otherwise, we'll stand on our brief.
Thank you very much.
Thank you very much.
Hussein versus City of New York.
Good afternoon, Your Honors. May it please the court, Jack Jascarin, the Law Office of Jack Jascarin, representing the petitioner pro bono. The petitioner is an 11-year veteran of the NYPD, recipient of 4 medals. He's still married to Miss Hussein. They've been married now for 22 years. They still reside together, raising their 3 children. He was awaiting promotion to sergeant when this matter occurred. We're asking that the court annul the decision and reinstate the petitioner, or at minimum, remand the matter back to the NYPD for a new hearing based on several salient points here. The first is the most serious charge against the petitioner was the menacing allegation. Prior to the hearing, the NYPD conducted its own investigation, and then that investigation of findings was then transferred over to...
That's not a part of the record. That wasn't a part of the hearing. Let's focus on all of the specifications where he was found guilty. Let's talk about that.
The only reason I raise this, Your Honor, is that this was left out, this was withheld from the petitioner. And he didn't know this to be able to raise it as an objection or raise it during the trial. This information, the NYPD unsubstantiated the first specification, the menacing allegation, and didn't...
The claim isn't based on that, so let's talk about what the claim is based on.
Right. The 4 specifications found guilty. Let's talk about that.
The first specification was the menacing allegation, which the NYPD unsubstantiated, but then substantiated during the hearing. The second allegation involved an allegation that he struck his wife.
October 11th, 2020.
Yes, ma'am. That allegation there. The hearing officer admitted a photograph that no one knew who took the photograph. No one knew what date the photograph was taken, and admitted that photograph into evidence and used that photograph to corroborate that allegation. The issue with admission
Was it authenticated by anyone?
No, ma'am.
Was there an objection to it going
Yes,
into
the
evidence?
objection, there was an objection made by his counsel at that hearing, and that objection was preserved. The third allegation, the third specification was that he didn't make a notification. He didn't, his argument is he didn't have to because the October 11th incident didn't occur, and with the second incident, the hearing officer found that his notice to his supervisor satisfied that requirement that he notified. And then the fourth allegation was that he threatened his wife on December, I believe it was December 4th, or,
And his son.
and the son on that date.
And also threatened the father-in-law as well.
And with that, the wife recanted those allegations subsequently to that.
That doesn't mean that the court can't find it. That doesn't, the fact that she recanted later doesn't mean that the court, that the hearing couldn't have made a determination about that, contrary to what she recanted, right?
The hearing officer never addressed her recantations. He actually asserted that she did not recant her the allegations.
Well, she was reluctant to cooperate as per the detective because she didn't want to lose her home if, the officer lost his job. It was very detailed, the domestic incident report, the supporting deposition on the October and I believe it was December incidents, very detailed.
And with regard to the photograph also, that was a sealed criminal record that was admitted. The petitioner did not consent to that admission and did not waive the sealing statute protections that he had for that photograph.
Anything else?
There's a few others. With regard to the entire proceeding itself, there was a mode of proceeding error that occurred because the NYPD deviated from its requirements to the way it carries out service of process. When that occurred a century ago, this court annulled that decision by the hearing officer. It was 1896, and then the following year, 1897, the Court of Appeals also annulled the decision by the NYPD when they violated and deviated from the rules governing service of the charges and specifications.
Are you claiming that he wasn't given notice of the issues?
There's the control.
Are you claiming that he wasn't given notice of the specifications?
He was not given the proper notification as per the law.
Based on,
The laws governing.
based on a case from more than 100 years ago?
There hasn't been this many cases regarding the trial room decisions, but because it's a mode of proceeding error, the mode of proceeding errors don't have to be preserved. They're non-waivable and can be raised on appeal. And then lastly, with regard to the shocking of the conscience, the court must consider the ramifications of his termination of his career and his pension.
But what we have to consider is whether it shocks the conscience to have a member of the police department who does not understand or does not act based on an understanding that domestic violence is against our laws. And I have difficulty seeing that as shocking the conscience of anyone in this city. So is there any support for your claim that terminating a police officer because of a finding of domestic violence shocks the conscience?
Particularly, he retrieves a gun, points it at the wife, at the son. I can go on and on, but
It might have been true in 1896, but today I don't see that as shocking the conscience. Are you arguing that we should apply an 1896 standard to this?
The NYPD has retained officers who have been found, engaging in
That's not the question. The question is whether terminating someone on that basis shocks the conscience. And I'm trying to find out if there are any decisions, certainly from this, for example, from this court, that we have found that terminating a police officer on the basis of domestic violence shocks the conscience.
I have not
You
found
haven't
that.
found any cases that so
I have not,
hold.
ma'am.
Thank you.
May it please the court, Devin Slack on behalf of respondents. Just on shocks the conscience, on page 17 of our brief, we cite 4 cases where this court has rejected shocks the conscience argument in cases of domestic violence where the allegations aren't identical, but they're very similar. That's Marks, Castillo, Joseph, Durdugan. Since the briefing here concluded, this court has done it twice more in Rooney and Torres. Aside from that, I just mentioned that of the many procedural arguments that the petitioner has raised in this case, only one of them was preserved. That's the objection to the authenticity of the photograph. The photograph, frankly, doesn't really matter all that much. Like, it's one piece of a much broader mosaic of evidence, including sworn statements from the petitioner's spouse and his son, a domestic incident report, and other items of evidence. But, you know, like, the photograph itself was authenticated, and at least there was a sufficient basis for the hearing officer to conclude that, because the investigating officer testified that that photograph was obtained from Nassau County Police, who in turn indicated that it was obtained on the day of the arrest. And then the petitioner's wife testified that on the day of petitioner's arrest, her son had taken photographs and shown them to the officers. That's more than enough to conclude that the photograph was what it purports to be, which is a photograph of petitioner's wife and her injuries. If there are no other
Counsel, what's your response to your friend's concern about the mode of proceeding error that doesn't require preservation?
I have a few responses. One is the court addressed, or at least confronted, an almost identical argument in Marks. There too, as here, it was not raised on the administrative level, and this court concluded that it had no jurisdiction to consider it in the interest of justice. Because this is an Article 78 proceeding, it had to be preserved for this court to consider it. I'd also say it's incorrect. Even if you apply the criminal case standard that the petitioner has cited, I think it's called Mackey, even in that case where it's a criminal context and it's not the same level of deference to administrative actors, the violation must rise to something of a constitutional dimension. There is no question that the petitioner received constitutionally adequate notice and an opportunity to be heard. There were written specifications. There was a full evidentiary hearing. There were written submissions after that. There was another record. There was another full record of another determination by the commissioner upon a full review of the record. And of course, there's an Article 78 proceeding. Petitioner received all the process to which.
And here, petitioner was required to notify the NYPD operations unit,
That's correct.
And he admitted that he did not do so.
That is correct.
Mm-hmm.
Thank you.
Thank you, Your Honors.
Your Honors, with regard to the notification to operations, the hearing officer found that that petitioner notified a sergeant was in the spirit of the procedure and did not hold that against him.
Do you agree that you did not preserve what you refer to as the mode of proceedings error?
I wasn't the attorney.
No, I'm not, I didn't mean, when I said you, I meant your client's lawyer, not just you personally.
No,
Do
Your
you
Honor.
agree that that was not preserved?
I don't know why it wasn't preserved, but my understanding is that it's.
Do you have a position on whether it was preserved?
I'm sorry. It was not preserved.
Thank you.
With regard to the statement that Ms. Hussein testified, there was no testimony from Ms. Hussein in this matter. The hearing officer based credibility off of what's referred to as a lifeless record. And again, with regard to the photograph was not authenticated by anyone. It was never shown to Ms. Hussein to say, hey, is this the photograph that was taken? That photograph was not shown to her, and that was admitted to by the hearing officer in the transcript of the decision, footnote 3. Thank you, Your Honors.
People versus Williams.
Good afternoon. My name is Florian Midell. I represent the appellant, Jamar Lee Williams. May it please the court. A number of arguments were raised on this appeal, but most of them have one common denominator, which is the fundamental rotten flaw in this trial, which was the false testimony of Shanta England, the only witness to testify about the murder, the only witness to identify Mr. Williams. We know this testimony
Counsel,
was false.
One of your claims in particular is that the court should not have permitted Ms. England to identify the man with the fur hood in Exhibits 58 and 59. How did you preserve that claim?
The claim that she should not have been credible as a matter of law?
Right.
That claim was preserved by counsel.
How was it preserved?
Counsel argued that the court should find her not credible as a matter of law.
Specifically at the time of her testimony with regard to Exhibit 58.
Regarding the counsel preserved they basically argued that her entire testimony should be.
Okay, but with regard to her testimony regarding Exhibit 58, was it specifically preserved?
That specifically, no, but I think that it would be fair to say that his preservation of her entire testimony as incredible as a matter of law should have covered her entire testimony.
On another issue, if we were to find that the 440 court was in error, would a proper remedy be to remand it for an evidentiary hearing or something else?
Well, as I noted in the reply brief, I think it could be a proper remedy to send it back to the 440 court, but then the 440 court would have to hold a hearing on an issue that this court could on its own decide based on the record. And if the court then ruled against Mr. William, then we would appeal and come back for that purpose. And so this court is in a position to rule whether counsel was ineffective for failing to bring the renewed motion to dismiss, and also ineffective for failing to object to the clear prosecutorial errors in this case, misconduct in this case. So I think, while sure, technically it could be remanded for that purpose, it seems like it would be a waste of time because this court could make that similar decision.
I just want to go back. You said that Ms. England's testimony was false.
Yes.
How did you, establish that? Why was it false?
Well, it's false because unlike many cases where there are competing testimonies, here we have her testimony and we have video of the actual murder. And the video of the murder may be grainy. It may not be as clear as one would like in the sense that we can't make out faces, but it clearly shows what happened. It shows action. It shows the actual murder. And so we can see that her testimony about what she supposedly saw happened cannot have happened. We saw it. We see it on video. The people's position seems to be that sort of famous Groucho Marx quote is, "Are you going to believe me or your lying eyes?" We can look at the video and we can see what happened, and her testimony doesn't match it.
That may establish that what she saw was inconsistent with what was on the video, but you argue that she invented it, and that and it seems to me very different. I mean, one of the things I learned as a trial judge is that people remember things differently. Two people can see the same event, can even see the same video and see it differently. So it seems to me that what you're talking about in terms of the video might establish that she was not credible, but it doesn't necessarily mean that she invented it or that she was intentionally lying or anything else. She just remembered it differently.
It's difficult to know what was in her head, but what we can
Right, so
say
what
is,
evidence do you have that she invented it or that she was lying intentionally?
Your Honor, it's because both cannot be true. It's not that it's not different perspectives or remembering things certainly a slightly different way. She says, just as one example, she says that she recrossed Morris Avenue, went back up the block, then heard Romeo say to Monkey, "Get me the gun." They go around the block, supposedly get the gun, bring it back, hand it over. All of that could not have happened because we know from the video it was only 20 seconds.
I understand your argument that it could not have happened, but that doesn't necessarily establish that she was intentionally lying or making it up. It just means that she remembered. On what do you base your claim that she was making it up or intentionally lying? Apart from the fact that it's different from what the video shows.
It's so fundamentally different, in my opinion, that it's hard to explain how she could have just been mistaken. You can't mistake a story that somebody goes around the block and gets a gun when clearly that didn't happen. That's just made up. I mean, I'm sorry, but that's just made up. Like you can't. It makes no sense because we know it couldn't have happened. It didn't happen. It was on video. And so there was no person that went around the block. We saw the video from the barbershop, which showed that angle. It would have shown a person walking the way she described it. It didn't show that. So we have something fundamental here that the district court, that the trial court should have seen made no sense and should have held as incredible as a matter of law. And I know that is an extraordinary remedy, and we've discussed it in the brief. It's rarely applied and it should be rarely applied. But if it doesn't happen in this case, where the testimony was not only manifestly untrue, but physically impossible, which is two criteria that the courts have suggested courts should look to see whether somebody is incredible as a matter of law, then what case is there where it would apply? A trial is not a free-for-all. A judge has a responsibility to serve as a gatekeeper, and the judge here didn't do that. Just briefly, Your Honor,
I just want to go back. Now, you're not disputing the fact that Miss England was, nearby. You're not disputing that, right?
Well,
are you? Because I didn't see anything.
I'm not disputing
I just
it.
want to finish.
I'm accepting that.
I just want to finish, if I can
Sorry,
do
I'm sorry.
that. Because I didn't see anything where there was any evidence even disputing the fact that she was there, at the scene, nearby.
I'm sorry. Are you saying you didn't see any evidence that she was, or that you didn't see this?
Disputing that.
Disputing it, right.
Disputing that.
Well, she identified herself on camera.
Yes.
And based on that identification, everyone assumed she was there. But there was certainly no independent evidence. No other witness or anybody else testified that she was there. It all came from her. But assuming she was there because she identified herself on the video, we know that she may have been in the general vicinity, but she couldn't have seen what she said she saw. She couldn't have. Thank you.
May it please the court, Catherine Trifon for respondent. Your Honor took the words out of my mouth. I was going to open with, it is undisputed that Ms. England was at the scene of the murder that night. It is also undisputed that she was an active member of this enterprise that defendant was a member of, the Macbalas gang. She sold drugs for them.
Counsel, I have a question.
Yes.
We're talking about things that are undisputed. In the grand jury testimony, it seems to me it's also undisputed that the only evidence that puts defendant anywhere near the murder in December was the testimony that he was standing on a corner a block and a half away. Is there any other evidence in the grand jury testimony concerning any relationship between defendant and that murder?
To my recollection, Your Honor, of course, there was a great deal of grand jury testimony because of the scope
I understand
of the
that.
charges.
I'm asking you about a very specific part of it.
To my recollection, Miss England was the only one, as at trial, who put the defendant at
I'm not talking about the trial. I'm talking during the grand jury.
I said as at trial. I'm sorry. Yes, in grand jury and at trial. I believe she is the only one who put him there.
And her testimony about him at the grand jury was not that he shot a gun or had a gun, but only that he was standing on a corner a block and a half from where the victim was killed.
That's correct.
Okay, so I don't understand how, and that was not something that the defense counsel knew at the time he made his initial motion concerning the adequacy of the grand jury record for his motion to dismiss the indictment because of the inadequacy of the grand jury testimony, right?
I couldn't say what he knew or didn't know.
He didn't have that part of the grand jury testimony at that time, correct?
I don't believe he did.
Okay. If, as I recall the record, he did not have that part of the grand jury testimony and later obtained it, and yet at that time failed to make a motion to renew his argument that there was a basis to dismiss the indictment based on the fact that the only evidence connecting his client to the murder was that he was standing on a corner a block and a half away from the victim. Why wasn't it a inadequate representation by counsel to fail to move to renew that motion at that time?
Well, as we argued, number one, the motion court had reviewed the minutes and
well, I
found them
know
to
the
be
motion court
sufficient.
reviewed the minutes, but as a judge, when I read minutes or when I read a record, I depend in part on counsel to show out, counsel on both sides, to show to me what is in the record that I might not otherwise weigh heavily. So the fact that defense counsel didn't have that information and couldn't argue that to the court because it didn't know it might have meant that the judge missed it. Judges do miss things.
Sure, but you're also making the assumption or drawing the connection, Your Honor, that Shanta England all we needed Shanta to do was put the
I'm not
defendant at the
talking
scene
about
of the
Miss
crime.
England. I'm
No,
talking,
but I'm saying at the
wait. I'm not talking about, Miss England isn't part of my question, really. My question is the absence of evidence that connected defendant to the crime.
Sure, but
If there was no other evidence connecting defendant to the crime, and defense counsel didn't know that at the time he made the first motion and later knew it, why isn't it ineffective representation for him not to have made a motion to renew at that time?
Because there was other circumstantial evidence connecting defendant to the homicide.
Wasn't it the group association?
Correct.
Among other information that was presented to the grand jury. In other words, it wasn't Miss England's testimony alone that puts him a block away. There was other information presented, correct?
Correct. It was the surrounding circumstances of the whole scope of this murder, including and not limited to significantly defendant's motive to kill Hairston.
But a motive and being a block and a half away when a crime occurs.
Circumstantial evidence.
Excuse me. So now we have him a block and a half away and a possible motive. Is that enough to indict?
When you consider the totality of the evidence presented against this man, it is. It is enough to indict. And again, all we needed Shanta for was to put him at the scene, which she did. We then had we had the motive, we had the ongoing criminal enterprise, and we had the hospital record showing he had been slashed, that the gang membership, and again, the grand jury presentment focused on this.
That's just another piece of the motive evidence.
But circumstantial evidence is enough to get you there.
So he knew he was part of the gang, he had a motive, and he was a block and a half away. Is that really enough to indict?
Yes, yes. And it was not ineffective. More importantly, it was not ineffective for counsel to fail to rebring the same motion that he had
What
brought.
strategy could possibly have underlay that decision not to make that motion to renew? What valid strategy?
I believe he, if I'm making suppositions, he probably felt the same way I did, which was, all right, we had enough to get an indictment for this, and we'll suss the rest out in litigation. If there are no further questions, if I may just, I'm sorry, I know my time, but as to counsel's matter about the 440, I know what the proper remedy is, but I also just wanted to point out to the court that with regards to sufficiency or weight, because there was a stop deliberations charge and the jury did not deliberate on the remaining charges, they only deliberated on the homicide, the proper remedy would not be to dismiss the indictment. It would be to send it back for a retrial on the remaining charges that they did not consider. Thank you.
Justice Schulman, just to take your point about the grand jury testimony, two things. One, motive was not part of the grand jury testimony. There was no evidence about motive in the grand jury because the video that provided the motive, which was the bodega slashing 3 days before, was not presented to the grand jury, so that's not part of it. The issue about whether everyone was in the same group, that only came from Shanta England at the grand jury because only she placed members of the group at the scene of the murder. No other witness did, no other evidence did. And so even though, yes, there was other evidence during the course of the trial that Mr. Williams and these people were all sort of supposedly part of a gang, only she placed all those people on the scene at the time of the murder.
And was that part of her grand jury testimony?
Well, at the time of the grand jury testimony, they obtained indictments against multiple people for the murder, which included the other people. Those cases all went away.
Counsel, we don't have the benefit of the trial judge's decision on the sufficiency of the grand jury minutes, correct?
Correct. The file is lost, but having practiced in the Bronx many years, I know that generally it simply says the grand jury minutes are sufficient, and that's. Thank you.
CSI IT versus Dungy.
Your Honors, Alex Tallel, Ice Miller for plaintiff appellants requesting that George A. Gasper be permitted to participate in this appeal.
I'm sorry.
I'm Alex Tallel for Ice Miller and the plaintiff appellants. I'm requesting that George A. Gasper be allowed to participate in this appeal.
Pro Hoc Vice.
Pro Hoc Vice, correct.
Did you submit an application?
We did indeed.
Go ahead.
And just to clarify, Your Honors, we're on for 6, 1, and 5. Is that correct?
6, 1, and 5,
Thank you.
which has already begun, unfortunately for you.
Good afternoon. May it please the court, thank you for the opportunity to appear pro hoc vice. My name is George Gasper from the law firm of Ice Miller on behalf of the appellant plaintiff. This case is about whether parties who have agreed to exclusive jurisdiction in New York can be sent to litigate elsewhere under the first filed rule because the defendant, not the plaintiff, but the defendant preemptively filed a claim in another state that is not the same as what the plaintiff has filed here in New York. New York law is clear that form selection clauses are presumptively valid, and here the defendant never even argued that the form selection clause was invalid or that it did not apply.
Counsel, aren't there circumstances, though, even where we have a valid form selection clause, that it was held not to be enforceable for some reason? And the reason it was held unenforceable here was because there was a compulsory counterclaim involved, that there really was no choice but to assert that counterclaim in the Florida action. So under those circumstances, why should we enforce the form selection clause?
Two things, Your Honor. What was ruled to be a compulsory counterclaim in Florida is fundamentally different than the claim that's brought here. So we are talking about two different claims. In other words, the two cases could exist in parallel form. And I'm not sure from the trial court's record that
But why would we want those two cases? Florida, once he had to bring that claim there, why would we have a second action going over here? That's a more comprehensive claim. It involves the same issues, the same topics. Why would we go forward with the New York litigation where it's undisputed that that was a compulsory counterclaim in the Florida action?
For two reasons. I believe New York law is clear that form selection clauses are presumptively valid. And here, going back 5 years
They're presumptively
ago,
valid, but they're not absolute. If there's a compelling reason why they should not be enforced, the court is not just going to blindly enforce them. So why isn't this a case where it makes sense not to enforce the form selection?
I think we have two issues.
Especially because it was the same people who brought the action in Florida and brought the action here. It wasn't like one party on one side and one party on the other. It was the parent company and the subsidiary both brought both actions. They could have brought them all in one form. Why should we allow it to be separated?
So there are a couple things to respond to. These actions, the holdings company could not have brought its case here in New York. Mr. Dungy is a resident of Florida. Those claims would have had to be subject in Florida, and the claims that gave rise to the New York case were not even known. What's alleged in the
Right, but once
complaint.
Holdings brought that action in Florida, why would the subsidiary's claims also not be litigated in Florida? And why would it make any sense to bring a separate action here?
Well, because these parties 5 years ago negotiated and agreed to the fact that these claims would all be heard by a judge in New York, governed on a contract that's governed by New York law. And
Right,
here
but if
we have a judge.
If we allow the claims to go forward here, we're going to have two courts addressing the same issues, which is the effect of the severance agreement and how to interpret the severance agreement.
Well, Your Honor, it is not clear, with all due respect, that the courts would be addressing the same issues. One of the arguments Mr. Dungy has made in the state of Florida is that the restrictive covenants in the holdings operating agreement do not apply to him at all because he is not an owner, rather a company that he owns is the owner of those shares. So he has argued successfully so far there are no restrictive covenants on him in the Florida litigation. So sending this case down to Florida to determine whether the New York employment agreement governed by New York law prohibits the non-solicitation activity at issue is not the same as what's going on in Florida. They are two fundamentally different matters. We believe that the form selection clause is exclusive. The trial court referenced that there may be an ambiguity.
It seemed to me that that clause was a little bit funky. I mean, it said that the action could be brought by any, that any action brought by any party may be instituted and maintained only in the appropriate court having jurisdiction over New York County, New York. I mean, I find that not the clearest form selection clause I've ever read, and somewhat contradictory. And given that the action in Florida seems to be more comprehensive, what would be the sense of having the case here too? I mean, we in New York, and in the commercial division where I guess this case, handle cases with law from all over the country, from all over the world. Why can't the Florida people handle something that deals with New York law? So it's a couple questions.
Sure, it's a good couple of questions, Your Honor. It's worth noting Mr. Dungy, the defendant, did not argue at any point that this provision was inapplicable or not binding in any way. This was raised by the trial court at the oral argument. There was no briefing on it. There was no request for briefing on it. There was no attempt to resolve the ambiguity as required by New York law. And one of the things, and I think this relates to your question as well, the trial court record is not at all clear. We have a so-ordered transcript without a reasoned decision. And what it appears to me, trying to read the best I can through the transcript, is that the court thought there might be some ambiguity, and in lieu of addressing and resolving the ambiguity.
Even if it's a fully enforceable form selection clause, because the Florida action was commenced previously, and because it will have a preclusive effect in New York, whatever is determined there, what sense, why wouldn't it be unjust to force this defendant to litigate in both places? Because he's going to be precluded, collaterally stopped from bringing, a contrary claim in New York once a determination is made in Florida.
We don't believe it would be unjust, Your Honor, because they're different claims. But more importantly,
Right, but if he's released from the severance agreement in Florida, it will release him from any restrictive covenants. If he's not released, he loses that argument.
we disagree with that, Your Honor. But more importantly, Mr. Dungy here, the form selection clause provision here has never been used before to say, in the face of a valid form selection clause, 3211A4 can send a party out of state. It has never, based on cases either party has cited, has never been used
Thank
to
you.
invalidate a contractual provision.
Thank you.
Good afternoon, Your Honors. Christy Blaze from Felder Law for the respondent, Mr. Dungy.
Counsel.
Yes, Your Honor.
Maybe I'm mistaken, but in the December 8, 23 decision, the Florida court, besides saying it has to stay here because of the compulsory counterclaim, didn't the Florida court make a finding that the plaintiff waived the right to enforce the form selection clause?
That is exactly right,
Now,
Your Honor.
And that took place before the decision here on July 2024, right?
That did, Your Honor.
So what is New York supposed to do in the face of a decision by our sister state court, which we have to give full faith and credit to? And there's been no appeal of that decision, correct?
That is also correct, Your Honor.
So now they want to have us come here and undermine a decision that's controlling. Am I right?
That is exactly right, Your Honor. And those were some of the first points I was going to make, so you beat me to it. The court in Florida decided in December that these claims had to be there. They have to be there compulsory.
And that court's going to make a determination as to whether that severance agreement is or is not enforceable.
That is exactly right. And to my colleague's point, when the parent company chose to sue in Florida, it could have sued up here. That first contract on which they sued did not say they had to sue in Florida. They could have sued anywhere. They could have chosen New York. They want to sue in New York now because they're not doing so great down in Florida, as you mentioned, right? The court has already found that these same restrictive covenants don't actually bind Mr. Dungy. The conduct that they're complaining of is not something that is actually prohibited by contract. So, Your Honors, we've got a dismissal below from the commercial division. This is actually just like a case that came out 2 years ago, 2 days from today, that I believe two of Your Honors were on the panel for that, A&M Valuation Services. It's almost exactly the same, and that the other case, the other state in which litigation was pending was California. There were contracts that had a much clearer mandatory jurisdiction and venue here in New York. And both the commercial division and this court said, we are dismissing this in favor of under 2211A4 because, again, the litigation in California involves the same parties, same series of alleged wrongs, same causes of action. It was commenced first. It's further along in discovery. And the court there, just like the Florida court here, had decided on a motion to dismiss that the right to try to enforce a New York forum selection clause had been waived and that the claims were compulsory. That is exactly what we have here. And Judge Masley found that below in her decision.
Thank you.
Thank you.
Very briefly, we were not able to bring any case in New York. Mr. Dungy was not a citizen here. What gives rise to jurisdiction in New York is the breach of the employment agreement. So this was not a strategic choice. Second, with respect to this Alvarez and Marcel case, and I'm glad counsel raised it, there was not any binding applicable foreign selection clause in that case at all. That case related only to exclusive jurisdiction in New York federal court, which didn't apply because there was no diversity, there was no federal question. So nobody was arguing in that case that 3211A4 should trump what the parties had privately agreed to. And even in that case, once the court said there's no jurisdiction, then the court got to 3211A4, but there was no forum selection clause provision in that case. As I said earlier, we believe that Mr. Dungy is asking the court to make new law, which is to say that if there's a valid forum selection clause provision, then it would not be binding in the event 3211A4 could be used as a basis to set aside a binding provision. And here, the use of the word may is permissive in the sense of you may or may not bring the case, but we respectfully submit that the trial court's reading reads out the word only. You cannot read that provision to be permissive with the word only in it. It may only be brought and maintained in New York.
Thank you.
Thank you.
Rockmore Contracting versus City of New York.
Good afternoon, Your Honors. My name is Jean-Pierre Van Lent from Cullen and Dyckman, representing the appellant Rockmore Contracting Corp. Your Honor, we are seeking reversal of the Supreme Court's summary judgment decision dismissing Rockmore Construction's claims for delay damages in the city project.
You would agree that the hurricane situation was not the fault of the city?
I totally agree with that, and that's a completely separate argument from the money case, which involves approximately $4.6 million. Hurricane is $200,000. We'd like to focus on the argument that the Supreme Court based its decision dismissing these two discrete categories of damages, extended field office costs.
There does seem to be law out there already that you can't use the bid amount in collecting damages, in assessing damages, that is not allowed and that's improper. So how did they not use the bid amount in this case in their claim for damages?
Your Honor, that's this court's decision, 5 Star Electric.
That is what I'm referring to,
209
versus Pregno.
AD 3rd 464 has two holdings. One, which is totally consistent with New York law and is your question, is that you can't use bid amounts for labor elements, costs of labor and pricing of labor.
I don't know, that might have been an argument being made, but I went and read the decision, and the case does not make that statement of law that you're saying it makes. It doesn't carve out labor law from other type of damages in the statement that you can't use bid amounts.
It allows the use, it holds that the modified total cost method, which includes bid numbers for field office costs and site overhead, is proper and was properly applied to extended field office damages and extended site overhead. Your Honor, there's 10 different decisions, separate decisions in 5 Star. And in the prior history for this court's decision, you'll see it identifies those claims that were found for which the modified total cost method using bid numbers was found to be proper. In the remand decision to the Supreme Court, the court remanded not for determination of the amount of damages, but for apportionment of liability for those damages. And in the remand decision, Judge Borak identifies those categories of damages on remand to which he's to apply apportionment, and one of those is additional and extended general conditions, which are extended field office costs and extended site overhead. Your Honor has to understand, and it's in the record before this court, in 5 Star record, Electric.
So you're saying we should go
And it says-
beyond, what our decision says and go back
It's
and
not
look at this
beyond, it's-
Supreme Court record to decide? I'm just trying to understand what your argument is.
It's the
'Cause
nature-
You're arguing about things that happen below versus us just looking at what our precedent is.
It's the nature of the damages, Your Honor. Bid numbers for field office costs and site overhead are fixed time-based costs. They're rental of equipment, project management based on salaries. They are calculated for bid purposes by the original contract period. It's a multiplication exercise. They don't involve any inherent unreliability or speculation. Bid estimates for labor, which is hours and pricing for costs of doing thousands of tasks, coordinated tasks on a major construction project, are considered, as a matter of law in New York, to be speculative and unreliable. In this court's decision, upholding the use of the modified total cost method for extended field office and extended site overhead, bid numbers were used. There was no dispute that the plaintiff in Five Star Electric used bid numbers as the modified total cost method for those two categories of damages, which are the same categories of damages which the Supreme Court dismissed in this case, citing the inapposite wrong holding. I don't want to say the holding was wrong, but citing the labor holding of this court, not the directly applicable holding of this court, that the modified total cost method can be used for these two types of discrete damages.
Did this court explicitly say that? Did this court explicitly make the distinction that you're arguing?
Yes, I believe it did, because the modified total cost method is the same. It relies on bids, but it's the nature of the bids that are relied upon, which is the difference. You cannot reconcile this court's decision in Five Star Electric on a theory that bid numbers are not allowed at all in calculation of damages, because that's what this court said. You couldn't say it was properly applied without saying that the bid numbers were properly applied.
Thank you.
Thank you.
Good afternoon, Your Honors. Alina Jerker on behalf of the city. This argument is wrong on so many levels, and I just jump right in. But first, maybe as a side note, it's not even the only argument we make, and they don't address the argument that even if this were all true, they still waive these damages by not complying with Articles 11 and 44 of the contract, and they don't even address that here. I mean, the point is, coming back to modified total cost, that modified total cost isn't some sort of term of art with a set definition, and it's not, as they purport to suggest, something that this court approved of in Five Star. It's the exact opposite of the holding that this court had in Five Star, which is a recognition that in public works contracts in general, the use of a bid price to set a baseline for the difference between that and what ultimately are the total costs inheres a bunch of estimates and a bunch of assumptions, and that does not reflect actual costs. On these contracts specifically, what Rockmore agreed was that if it were going to try to collect additional costs, they would have to be actual costs, not estimates that it creates by grouping together without breaking by delay, without anything else, a bulk of its estimates from its lump sum, and then here's what it cost me afterwards, and subtracting, because what that ends up with is creating an incentive in the entire system for people to bid low and then say, oh, my damages are much higher because my bid was lower, and so, oh, look, this cost is higher. That just breaks the entire process, and that's why the contract requires actual costs and waives damages that don't reflect actual costs. And they say now, oh, well, that would have been very difficult to do. But if you just admit now, and in their brief, in their footnote, they explain the costs, these excess field office and site office costs, they are just labor costs. They're just the same. They are monthly salary-based payroll for job site administration, which means they had records, and they could have submitted actual records when they made their request and their verified statement of claims.
So you disagree with your friend that there's a difference between labor costs and those other costs that he's referring to? And there's no you don't get a pass for being allowed to use bid costs with respect to the EFO and ESO, correct?
Yeah, for many reasons, absolutely. First of all, I think while this court has, in 5-star, it involved labor, but there was that wasn't an argument that was made that this was somehow confined to labor. There's a third department case, Novak, that actually applies this exact same logic to site overhead costs, right? So there's no logical reason it would be any different. The point is, when they make a bid, they make a big lump sum bid. I'm going to do this contract for $15 million. And now, take it on my word, when I estimated the amount of, even if the overall bid is reasonable, there are assumptions in there. Here's how much this will cost, here's how much that will cost. If it turns out that the site overhead costs are higher, their ultimate costs are higher. If they end up lower, they make a larger profit. And what they're doing by saying, well, now take it at my word, there's an ascertainable value within that lump sum, although we never got to review it. And that should be the baseline. And any cost more than that has to be attributable to the city. It's a bunch of inferences, and that's not actual cost. Actual cost is, here's the cost, and they say they have it, a monthly cost. They should have just submitted that monthly cost. They could use their payroll records and then comply with the contract. And so even putting aside the bid price, that failure to comply with the contract and to provide a breakdown and to provide documentation means that there's a climate that allows for fraud and misuse of public funds if we don't require our contractors to do what they promise to do and provide that documentation.
Now, you say that the plaintiff didn't provide notice, but I thought I saw somewhere that I think it was the contracts manager or something, saying that since the mid-2018 was providing those notices to the city.
So from what I understand,
Doesn't that, that raises an issue of fact right there, so,
Well, so there's not really an issue of fact because it's not the same thing and it's different things. So under Article 11, what they were required to do is provide payroll and several things to show that, on an ongoing basis. But what they didn't do, they didn't break down their records. They just provided the bulk of the records that you could sort of figure out that we're incurring additional costs. So that wasn't compliant. But by the time they filed their verified statement of claim, which is the substantial completion submission, they submitted this expert report, and that expert report was purporting to provide that breakdown, but did not break anything down. So it should have said, for the additional costs that we incurred as a result of the city's delay from this, here are the amounts we attribute to it. But instead it just said, here's my total cost, here's my total estimate that I had in the beginning for what it would be, therefore we've supplied. And so whether there was some additional records and payroll records and additional records provided during the course of the contract, that doesn't absolve them of the responsibility to submit a properly documented, verified claim with all of the material that needs to be in there to be able to assess whether or not they actually incurred actual costs.
Right, and that was upon the acceptance of the substantial completion payment?
Well, there's two things. So Article 11, there's multiple stages of waiver. The contract is a little bit confusing in that sense. So there's an initial waiver of any damages that you don't make a request for under Article 11. That's like periodically. Then at substantial completion, there's a big payment, and there's an additional waiver there for anything not included. And then there's some true-up payments, and there's an additional waiver for not including and carrying forward any existing claims there.
The reason why I'm asking that is because I was also under the impression that, plaintiff even denied receiving payment.
I don't believe there's any allegation that they, with respect to the
payment.
Well, they haven't. I think that process isn't complete. They filed this lawsuit. So what they haven't done is complied with Article 11. At this stage of this sort of process, they've submitted their substantial completion verification request, and nowhere in there have they complied with the part of the contract that would have required them to do those breakdowns.
Thank you.
Thank you.
Your Honors, there's nothing confusing about the contract. There are no labor elements to the two categories of claims of field office and site overhead. The contract defines work at Article 2.1.35, and it just says labor, and then later on it says management, superintendence, and supervision. that management superintendent supervision, that is site office overhead. It's not labor. So the bid numbers are not for labor in use of the modified total cost method for these two discrete categories of damages.
So,
Novak case that counsel cited.
So Five Star Electric deals, you're saying, completely with labor costs? Is it exclusively with labor costs? The five.
No, it has two. It said no modified total cost method for labor costs, modified total cost method appropriate for field office and site overhead. Also, Your Honors, there has been no payment of the substantial completion requisition. So there's been no waiver under Article 44. You don't waive it. If Your Honors take a look at our two verified statements of claim in the record, they itemize, they break down. The counsel speaks to Article 11. Article 11 is during the duration of the contract mostly. 7 days after a notice, you give after a delay event, you have to give notice of the condition causing delay. And thereafter, every month, you've got to give damage statements. We did that. We have affidavits in a record that we did it.
Thank you.
They produced
Counsel, thank
no
you.
records. They didn't meet their
Counsel,
burden.
thank you. Thank you.
Thank you, Your Honor.
Bansa Ferrer versus SREP.
Good afternoon, Your Honors. My name is Howard Altman. I'm with Casco and Klupfel. I represent a third-party defendant appellant, Fitzcon. I know it's been a long day. You don't need to hear the same arguments twice, so unless you have any questions from Fitzcon, I will defer to my colleague, Shrep's counsel.
Okay.
Thank you.
Good afternoon, may it please the court. Magdalene Skunzos on behalf of the defendants, third-party plaintiffs, respondents, Shrep, and Foundations Group. Your Honors, we ask that this court reverse the grant of summary judgment to plaintiff on his labor law 240 subparens 1 claim, because there's a question of whether the incident at issue even involves a gravity-related risk. This is a case where This is a case where the plaintiff was charged with moving a delivery of materials at ground level. There's a video that captured the incident. In fact, during oral argument below, Justice Hagler said at one point, I can't really tell if he's standing on the ground or if he's standing on the first piece of wood.
Wow.
That's a question for the jury to decide.
Isn't he standing on a pile of beams that's 3 feet high?
At the point in the video where he falls, he does stand on top of a pile of beams. But
So when the accident occurs, he's on a pile of beams that's 3 feet high, and he falls into the beams, right?
He lands on top of the beams,
So he
correct.
falls on the beams. So why isn't that an elevation-related risk?
Well, two
because
reasons.
at the time of the fall, he's 3 feet elevated off the ground.
Well, two things, Judge. First, there's evidence in the record that he didn't have to be standing on that pile to do the job.
That's the recalcitrant labor, but there definitely was evidence in the record that it was a regular procedure for workers to step on the pile of loose beams to transport them, and it was done on a regular basis.
That is what plaintiff claims, that was the only way. There's a testimony in the record by the
Whether or
plaintiff.
not it was the only way, there was clearly undisputed testimony that it was commonly done. Whether or not it was the only way for it to be done, it was done all the time. And there was testimony.
That's plaintiff's testimony, which we believe calls.
Sorry, what?
But I also believe.
I'm sorry, I didn't hear your answer.
Sorry,
I didn't hear the answer. Let me just.
It was plaintiff.
What?
Sorry,
I
Judge.
just wanted to hear the answer to my question.
Sorry, could you repeat I'm sorry. You said there was testimony that.
Wasn't there undisputed testimony in the record that workers routinely stepped on top of those beams to transport them?
There was testimony that workers were doing that. The video does show otherwise, that they were also walking around, and that was possible
Right,
to
but
walk
I'm
around.
saying even if they sometimes walked the other way, clearly they were regularly walking on the beams.
When we say regularly, Judge, this was a delivery that was made that day and that they were moving that day.
It wasn't the first time they were delivering beams, was it? Or using the beams or transporting the beams? It was an ongoing process, wasn't it?
I'm focused on this delivery, Judge, and this.
But how can you, okay.
Well, let me move on to
Go
the.
ahead.
Sorry, counsel. My understanding is that there was testimony from Foundation Superintendent who testified, A, that it was a dangerous recurring condition of the beams, B, that it was the regular procedure for them to walk over it, and the video shows that they were walking regularly over it. There was something in the video where, depending on how you hold the back end of this beam, they may be able to walk on the side, but generally the way the pile was configured there, he acknowledged that that's how they were removing the beams, and that it was a dangerous condition. That's a record.
I believe the testimony was that either before or after he said once he wanted it done differently. That's my recollection of the testimony. I'd like to just point out that
I'm
there's.
going to ask you one question that's totally unrelated, and you,
Oh, sure.
you can come back to it, but I just need a clarification on this issue, and this has to actually do with the indemnification issue.
Okay.
With FitzCon. Are both Foundations and Shrep moving for indemnification from FitzCon? Are they both separately moving for the indemnification?
My understanding is they both sought the contractual indemnification from.
Okay, and is anyone, I know that there's a debate about whether or not there is indemnification, but is anyone contesting whether that indemnification should be conditional or not conditional?
My understanding was the decision said it was conditional
Right,
indemnification.
and is anyone contesting that determination that it should be conditional rather than absolute indemnification?
As to Shrep, Your Honor, we submit, there's absolutely no evidence that Shrep had any involvement at the site, and it should be.
Because I couldn't find this in the brief. Are you making an argument that if we find that Shrep is found not to be negligent, that indemnification should not be conditional?
Yes.
Okay, because I really didn't see that argument in the brief that you were arguing about the conditional versus non-conditional.
I guess the brief was more focused on the 240 arguments and the 200 dismissal, but I thought that was made in the brief. Because Shrep had no involvement at the site. There's no active negligence. It's a limited liability ownership entity.
Okay, well, you're going to get rebuttal. Can you take a look at your papers and see if you made that actual argument?
Sure.
While we go on to the next.
Can I make one point I did not make just because of the
You'll
questions?
have time to come back on.
Thank you so much.
Yeah, you're going to get rebuttal, and you could address it.
Good afternoon, Your Honors. May it please the Court. Lisa Camo for the plaintiff respondent. Before we get on to other topics involving 240, I'd like to make some very quick factual points about the 200 argument. And that is, the defendant's position is that the superintendent, Mr. Creazu, that he testified he didn't arrive at the site till 7 a.m. The plaintiff said that he arrived at the site, he himself arrived at 7 a.m. and the accident happened at 8:15. So that's one thing, and that's.
Let me ask you, how could there possibly be liability as to negligence as to Shrep?
Well, there's some. Oh no, we're not contending that. It's Foundations.
You're saying there's no issue that there's no negligence on. So okay, I'm asking because I'm still trying to figure out the conditional. I know you don't care about that.
Yeah, no, we did not argue that because the party actually there supervising at the site was Foundations, and this
You're arguing that there's an issue of fact as to Foundations negligence.
Yes, with respect to the negligence, the Labor Law 200, there are questions of fact as one of their primary arguments is that the superintendent wasn't present at the site when the accident happened, therefore he could not have been actually supervising the work, as he testified he did other times involving deliveries. He admitted he had responsibility for deliveries, for the placement, this is a very narrow gate, et cetera. He also said in his testimony that 797, 798, he found it okay to walk over piled things, such as this work site.
You're saying at a minimum there's an issue of fact.
Yes,
You're not moving for summary judgment on that.
I just wanted to sort of spit it out while I had the chance, to be honest. And then, and the other thing I'd like to point out is it is by no means undisputed that the delivery occurred that day. That's what the superintendent said, but plaintiff said that this material had been delivered the day before and had been sitting there in front of the gate all that time. So that's another significant question of fact. With respect to the 240, I think, as the court can see from our papers, our position is that this was in fact an elevated work site. It's a sort of top-down video in a lot of respects. You can't always see exactly how
No,
high
you
this is.
couldn't tell that.
There's a point, and I'm sorry, I don't have the timestamp to recite to you, but you can see at one point there's a worker who goes by and it's like at the level of his thigh. It's at his upper thigh. And that's consistent with the plaintiff's testimony that it was approximately 3 feet. So what we have is the collapse of it's essentially a collapse. It maybe didn't collapse that much, but it's a 3-foot high work site. It implicates an elevation hazard. It implicates the need for elevation safety devices that was addressed by the expert. It was in fact even addressed by Mr. Cereio, who admitted that this material could have been moved in a different manner. So it's the absence of like a forklift, a knuckle boom, all the devices that he talked about, that our expert talked about. And it's also the failure to, alternatively, they didn't even attempt to brace or stay or hold this together. But yet the workers were permitted and certainly never prohibited, as would be required for either a recalcitrant worker or a sole proximate cause argument. That they were never prohibited from doing just what you see them doing in the video. When they're coming back and they have to lift up these big beams, they really, given this narrow gate, there really wasn't much choice, as the plaintiff, Mr. Braganca Ferrer, testified was the case. Unless the court has other questions, I rest on my brief at this point.
Thank you.
Thank you.
Do you want your 2 minutes, or it's up to you? What? Okay. I'll give you 3 minutes since you.
Thank you, Judge. I appreciate
you
that.
got shortened.
Thank you, Judge. It's been a long day, so I do understand it can't be easy sitting there. But nonetheless, I asked that the court affirm the order of conditional indemnification granted. I looked at my brief. I looked at the conclusion of our appellant's brief. So I'm sorry if I misspoke before. I asked for the affirmance of the conditional order of indemnification.
You're content to get the conditional?
I'd like the contractual, but what I said in my papers is what I said in my
That's what I
papers.
thought. Okay.
So I don't want to stand here and lie to this court, obviously. One point I wanted to make, first of all, Ms. Como pointed out there were several tribal issues of fact, which actually weighs in favor of reversing any grant of summary judgment below. Notwithstanding, I'd like to call attention to this court's decision in Cruz v. PMG Construction Group, LLC, a March 2025 decision, March 4th, 2025 decision, that pretty much stands for the proposition where there's conflicting expert opinion as to causation. That issue should be submitted to the jury. So summary judgment was denied to defendants on a motion for summary judgment to dismiss a Labor Law 240 subsection 1 claim. And in opposition, plaintiffs submitted an expert affidavit saying there was a violation. And this court decided where there's conflicting expert evidence, summary judgment should be denied. We ask that this court do the same here. Defendants had an expert saying there was no violation of 240 per 1. Why can't I say that today? 240 subsection 1, and plaintiff's expert says there was. So we ask that any credibility issue be submitted to the jury. We're not asking this court to dismiss the Labor Law 240 claim. We're just asking that it reverse the decision granting partial summary judgment to the plaintiff. I know this panel had a lot of questions for me before. Is there anything now that
Any questions?
Thank you very much for the time. I do appreciate it.
Thank you. Cereio versus Felder Village?
Thank you, Your Honor. May it please the court. My name is Joseph Pace on behalf of defendant appellant. In 2008, Fat Cat changed its pay structure so that instead of paying employees $8 to $10 per hour plus their share of nightly tips, the employees would receive a guaranteed minimum of $25 to $40 an hour. Now, there is no dispute that this 3- to 4-fold hourly rate increase was designed to fold in the tips that were previously passed on directly.
That increase in wages didn't release you from the obligations of Labor Law 196D, right?
We're not saying that it released us from the labor law obligations. What we're saying is under the 196D simply says that an employer cannot retain tips. But if a tip is packaged into hourly wages, it is not.
What cases support that that's a permissible approach for an employer to take?
Your Honor, this is an issue of first impression, so the court has never had to consider specifically.
Okay, so just so we're clear, there is no precedent for the position you're taking.
Well, there is no judicial precedent because the
That's what
issue has never been.
I don't know what other kind of precedent we're talking
Well,
about.
I mean, I think that there's no judicial precedent, but there is authority. And I think the authority is the plain language of the statute and Webster's dictionary, which says in order for a tip to be retained, it actually has to be withheld by the employer. Now, if a tip is collected...
This isn't a new statute, right?
It is not a new statute, but there's never been an occasion, to my knowledge, where a court has had to opine whether
But
or not...
it has been applied before.
It has been applied, but it has never been applied to this particular fact pattern. So it is, again, it is a case of first impression that requires that this court return to first principles. And I think that means that the court has to look at the plain language of the statute. Under the plain language of the statute, a tip cannot be retained unless the amount is actually held by...
I'm a little confused. There was an earlier decision by the trial court that found liability under the statute, correct?
That is correct, Your
And that was not appealed, correct?
That summary judgment order, no, that was not appealed.
Okay, so hold your breath. And then there was a trial on damages, correct?
That is correct, Your Honor.
And good, bad, or otherwise, your client made the mistake of representing himself.
Yes, that is correct. I would say for the worse, but yes.
And with the exception of cross-examining the plaintiffs, et cetera, there was no real concrete evidence that established that the 25 or 40, the range was incorporated the tips so as to make them whole, whereas they would otherwise not have been if they just got the $8 or $10 an hour in the pool, et cetera, correct?
That is correct, Your Honor, but by the time...
So then, it's not even a question of first impression. On what record are you possibly asking us to set aside the damages?
Because, Your Honor, the summary judgment order said that as a matter of law, the rate increase could not be used, could not be counted as tips that were distributed. We think that that was an error as a matter of law. So
It's very clear under the law that it's the employer's duty to maintain the records documenting over time how much tips were received, and has the burden of proof on that to show the documents to show that. So how could a trier of fact, just based on the representation that there's a higher amount paid, make a factual determination as to how many tips were actually received without having any documentation, which the statute specifically requires?
Your Honor, that was actually accomplished here. The purpose of the trial on damages was to determine the amount of tips that Fat Cat received during the relevant period.
Your client hadn't maintained records, right?
Well, he didn't maintain records. That's why he bore the burden below, and that's why we are now stuck on appeal with the calculation as to the amount of tips that Fat Cat received during the relevant.
What did he put in during the trial that we can consider that's part of the record?
The problem is by the time you get to trial, the court has already adopted the legal rule that the damages is equal to the total amount of receipts that tip receipts that Fat Cat received during the relevant period without any regard, without any accounting for the fact that the hourly wages were increased 300% to 400%.
So shouldn't you have appealed the other decision?
Oh, I don't think he was obligated to do so. You know, I think under the law in this department, he was permitted to wait until a final judgment.
Where does the I understand that's what he thought he was trying to do, but where does the authority come for him to do that? Where does it say anywhere in any statute that the employer can just arbitrarily decide to give a greater wage rather than make an actual determination as to what the amount of tips are and pass them over?
Well, so can I two answers to that? First of all, from 196D is completely agnostic as to the manner in which the tips are transmitted from the employer to the employee. So it doesn't matter whether they're directly transmitted from the tip pool to the employee or whether or not they're packaged up in the form of hourly wages. But the second point, which I haven't really gotten a chance to discuss, is there's a separate issue, which is 198A. 1A says that damages are limited to the underpayment. An underpayment is compensatory damages. And compensatory damages, the black letter standard for that is you look at how much they would have made under a lawful policy.
We don't really know what they would have made. That's the problem. I mean, he says it was tips incorporated. We don't know that. We don't know how he decided the salary. But you'll have rebuttal time. Unless, did you want to ask a question? Okay.
Good afternoon. May it please the court. Robert Kraus, Kraus Kluski, on behalf of the respondents. If this is a case of, well, this is a case of first impression, I don't think that this is the proper context in which to expand the law by creating an exception for liability, a defense to Mr. Sapir. I would point out some context. Mr. Sapir adopted an unlawful compensation scheme knowing it was unlawful.
How do you know that he knew it was unlawful?
There is an email from Mr. Sapir to certain of his tip staff in which he said, we are adopting this compensation scheme. We're now going on the books. It would be highly incriminating if anyone keeps, I'm saying in substance, if these emails are highly incriminating, please delete them. All communications going forward must be in person. And I will get the record on that. He also told his employees to conceal the communications. He failed to provide his employees with any of the required wage notices. And this, of course, goes to waivers because, as this court has held, Tamburino, any waiver, which is essentially what they're arguing, the employees waived their rights under 196D by accepting a higher wage. But that at least has to be, under Tamburino, a clear and unmistakable waiver. There's no agreement, there's no wage notices, none of the required records are there. We know also the Department of Labor goes further and it says you can't waive rights under 196D. At trial, there was a complete failure of proof. He didn't offer a single fact witness. He didn't call an expert witness. He had an expert witness earlier in the proceedings. He didn't call him at trial. He didn't introduce an expert report, although he had one prepared. And the court assessing the witnesses, we introduced 21 plus an expert, said that, well, they found our witnesses credible and they found that he did not submit any relevant, credible evidence, testimony, or arguments on damages, period, A17 in the record. My colleague says that Mr. Sapir couldn't enter any evidence. He was precluded from entering any evidence on, I believe, is the wages side, the offset. He said that twice, and he said it in his brief. It's simply not true. What he does is twist the motion court's decision on summary judgment, which held that he was liable for misappropriating tips. He had the burden of proof, didn't have any records, so he was liable for violating 196D.
And then the trial was on damages.
And then the trial was on damages. Never said you can't introduce any evidence on anything. It said it was not appropriate, it was not a defense on liability. Right. Implicit in that is come back and tell us on damages. Completely failed to do that. Do you have any further questions?
No.
I'll press. Thank you.
Thank you.
So, Your Honor, I just want to address the last point that my friend made about Mr. Sapir being able to introduce evidence. I think there are a couple problems with that, and the main one is they're judicially estopped from even making this argument because they argued at summary judgment that the law precluded any consideration for the higher hourly wages. They prevailed at summary judgment. Then in their pretrial briefing, they said that the summary judgment order conclusively established that offsets were unavailable as a matter of law. They prevailed on this one more time, right? They cannot now stand before an appellate division and say that the door was open, that Mr. Sapir was free to introduce evidence in support of an offset claim that they successfully argued below was barred as a matter of law.
Well, but what barred Mr. Sapir from getting all the restaurant receipts of the tips, whatever they are, and say, here it is, pull it, here's the numbers, let's go with the 25 and 40 per employer, and just do that kind of analysis on damages. People do that all the time.
Yes, but the court did not permit him to do so because the court held as a matter of law in its summary judgment order that Mr. Sapir was, and I quote, liable for all of the gratuities intended for its employees. That's on page 476 of the appendix. Now, I understand their argument to be, well, there's a difference. They just said he was liable. That doesn't go to damages. In the tip retention context, There is no difference between liability and damages because if you retain a tip, you are liable under 198(1)(a) to pay back that tip in the form of an underpayment. Liability and damages in this context are one and the same.
Thank you. Thank you, Counselor.
Sorry.
These are long days, Jesus.